Welcome back to the Elder Law Out Loud podcast. I'm Carla Ray here with the CEO and founding attorney of Florida's largest elder law firm, Family First Firm. I'm here with Jeff Hotzen once again. And today we are talking about a topic that comes up in our office quite often, and that is the issue of estate planning for blended families. So many families are looking, all kinds of ways these days. There are a number of different ways you can make a family, and we have seen them all. And let's face facts. I mean, we're an elder law firm, so a lot of times our clients are getting up there in age. They're maybe on their second or third marriage by the time they come to see us and start estate planning, and they've accumulated both assets and new family members throughout their time in those various stages of marriage. So doing estate planning for those types of clients is a little bit different. It's never going to be boilerplate.
Yeah, generally the focus there is ensuring that the kids are being protected. You know, that a lot of times people say, hey, I want my spouse to be taken care of, but I also want to make sure that they don't blow everything or leave it to their children or a new spouse if they get remarried. And so my goal is to make sure that there's still something for my kids. You know, now, again, things can look very different. And you can be in a situation where you've been remarried for 40 years. Your new spouse helped raise your children. You know, they see your kids as your own. Maybe they have their own and you helped raise their children. You know, in those situations, it tends to be more kind of like, well, they're all ours. You know, it's like the Partridge Family, not the Partridge Family, the Brady Bunch.
Yes.
Yeah, the Brady Bunch. You know, which is, they all raised them together. However, we do also see people who get remarried later in life. Oftentimes for companionship, maybe they're a widow or widower, and just, you know, want someone to share kind of those golden years with. And in those situations, it looks a little different because their kids are probably adults, 30s, 40s, 50s by the time they get remarried. And the idea of, you know, this new spouse treating their kids, their adult children, as their own.
The adult kids are like, I don't know this guy.
And you know, he's saying the same thing about the kids. You know, like, oh, I don't have any like real close feelings for them. Yeah. So you know, that's the challenge, I guess, is that you know, in those situations, you really want to make sure those adult kids are protected because I don't think there's going to be a lot of devotion from that new spouse to making sure that they're taken care of or protected through this process.
Yeah, and so you know, the stereotype I think that we see in movies is the gold digger. You know, second or third marriage, and it's a 20-something floozy going after a guy who's, you know, knocking on a nursing home's door.
That's right.
Talk about those situations where,
I'm trying to remember, that was a real life thing. I'm trying. What was the woman's name? That blonde woman who married that really old
yeah,
guy. So she was a
Anna
model.
Nicole Smith.
Anna Nicole Smith.
Yeah,
Thank you. Yeah.
and then she dies.
That's right. Yeah.
You know, it's like, oh,
Yeah.
may she rest in peace.
There you go.
But that's kind of a deathbed wife situation, and you have a real life example of that in your own family.
Yeah. So that happened with my grandfather's father. He was a widower, got remarried late in life. You know, so it was actually twofold. He added her name to everything because they were married, and that's what you did. He also signed a will basically on his deathbed, leaving everything to her. The circumstances of that will were incredibly shady. There probably was a lawsuit there. Of course, this goes back into the, you know, the probably the 30s, 40s. So chances, you know, the likelihood of him wanting to have done something back then was pretty slim, but I feel like, yeah, our society was not as litigious back then. But the bottom line is, you know, he was disinherited. And I think realistically unintentionally, you know, that truly the will that was signed was on his deathbed. From my understanding, his wife held his hand to write it, like sign it, like very shady stuff. But even that aside, without that, it still basically would have happened because he had added her name to everything. So unintentionally, he would have left it all to her, even without the will.
And so there are considerations for situations like that where, you know, if you're in your second or third marriage and you're maybe worried if something happens to you that your spouse will turn around and get married again, and then all of the marital assets, everything that has been jointly named, goes into this new relationship.
That's right.
So what is the tool to, I guess, avoid that or circumvent that?
Yeah, so generally we're using trusts. I mean, the easiest way to do it is to have a prenuptial agreement. That's the best. Now, it's not very romantic. People don't like them. There is the concept of something called a post-nuptial agreement, meaning you can sign it after you've been married. Um,
Even less romantic.
Even less romantic. That's normally the marriage is on the
Yeah.
rocks, and we're both going to try to save it, but we have this here just in case it doesn't work out. It's not necessarily something you want to start with, but the strategy that we normally use here are trusts and using irrevocable trusts. So we would have a trust set up for a family, probably revocable while one of the trust makers, we call them, is alive, and then when one of them passes away, then it becomes irrevocable. With the funds being able to be used for the surviving spouse, but the surviving spouse not having unlimited access to them. So oftentimes there's going to be an adult child, someone like that, who's going to be the trustee, who's going to be able to manage those funds for that survivor, making sure that that survivor has decent quality of life, decent quality of care, whatever, that they're not destitute on the streets, but they're not taking round the world cruises or flying private jets or things of that nature, spending down those assets and ensuring that the children are ultimately protected and that there is something left.
Um, in a scenario where this type of planning is not done and something goes into probate, do the kids have any claim at that point, or is the surviving spouse automatically going to take precedent?
So it's actually kind of flipped, and it depends if there's no will, we go to the intestacy statutes. The intestacy statutes state that if you're married and you have children from a previous relationship, it's half and half, is what the expectation is. For all the assets that will pass through probate. The other issue is for the homestead, that looks a little different. They'll say either the surviving spouse can, if their name isn't on the home, because if it's on the home, then it's theirs, of course. But if their name is not on the home, they get to live there for the rest of their life, and then it goes to the children of the predeceased spouse. That person who passed away goes to that person's kids if it was in their name when the surviving spouse passes away. Or the surviving spouse has, I think it's a 4-month period to elect to have a 50-50 ownership with the kids. So the spouse has 50%, the kids have 50%. That way they can sell it and each of them get half. Now, there is still laws to protect the surviving spouse. So we will see sometimes people say, well, I want everything to go to my kids. I'm going to cut out my spouse entirely. The state of Florida doesn't let you do that. There's something called the spousal elective share, which means that 30% of everything that person had when they passed away or gave away within a year of their passing, they can come back and get half of, or not half, I'm sorry, 30% of. So that's very interesting because it's not just what goes through probate. It's anything that's beneficiary designated. It's anything that was given away within a year prior to that person's passing.
Wait, so the beneficiary designation doesn't matter in that situation?
That's right. If the spouse, it matters in the sense that those funds will go to that whoever the beneficiary is, but the spouse can open up a probate, file an elective share claim, and go after those beneficiary designated funds.
So that would be like considered a litigation situation. It
for sure.
wouldn't be a standard probate.
No, generally not.
Wow. So that sounds like a nightmare.
It's crazy. I've been involved with some of them. It gets pretty nasty.
Like if you didn't like your step parent before, you're really going to hate them after this.
Probate is a great way to ruin family relationships. It's kind of like Monopoly.
Yeah.
Someone's angry,
Flip the table, flip the board up. We all know that
Yeah.
moment in the game. Okay, so that scenario really covers if there are children from a previous relationship and no children in common. What happens when there's a child in common?
It gets more confusing.
Yeah. Is that person like king in this scenario?
No, not it doesn't actually give them. So the curious thing about that, if memory serves, and admittedly it's been a while since I've handled any probate or definitely looked at the statutes here, but if my memory serves,
this is my job to keep him sharp.
Yeah.
You know?
Shoot, I wish I'd been given the questions beforehand, but memory serves. I think that child actually falls under the surviving spouse in the sense that the expectation is the money that would go or the funds that would go to that surviving spouse will then funnel down to that child. So it doesn't add like an extra layer on that same between the kids from the previous relationship and the kid from the combined relationship and the surviving spouse. I think they just fall back underneath there, and it still ends up being just the children of the previous versus that
The
new
new
spouse.
family. Got it. Um, Another attorney was explaining to me, another attorney here at Family First Firm, to be clear, not shopping this question around to other firms, but
Yeah.
that there are two different types of trusts that you can set up in a scenario like this. He was saying it was an AB trust, and then the other one escapes me, but they serve sort of different functions, and it's really to separate the assets that you're bringing into a relationship.
Sure. So, AB trusts, in my opinion, are more about percentages going separate ways. My preference when you're doing this sort of thing, especially when it's late in life marriages, set up separate trusts at the outset. Husband sets up his trust, has his assets in there. Wife sets up her trust, has her assets in there. The trusts specifically state what happens to those. They're not touching each other's stuff. There's no commingling. There's no confusion around that. So I don't. I'm normally not a fan of separate trusts. I think years ago they made sense. Um, when the estate tax exemption was a lot lower and more people were paying it, it made sense to kind of split everything up in advance because there was a lot of stuff you had to do at the time to take advantage of the unified credit and any gifting to your spouse, which would allow you to transfer assets without estate tax and things of that nature. But now that the estate tax exemption is so high, it's $15 million a person, $30 million for a couple. Um, that's just not an issue. So anymore, generally, I recommend set up joint trust because the splitting of that, doing the AB sort of those sorts of things, they're just not really needed anymore. But in these circumstances where we're talking about people with blended families, then they certainly come back into play where, yes, you want to make sure that there is some protected. We call them like family trust and survivor trust. The family trust is the irrevocable one that's designed to protect the family of the predeceased spouse. The survivor trust is obviously for the survivor, and oftentimes we'll split assets, whether it's 50-50 or 60-40 or whatever, between those. The survivor trust is able to be used by the survivor however they want to. That's the cruise around the world, if that's what they want. The family trust, the income from that trust can be distributed to that survivor every year. The principal can be used for the survivor, but generally you're going to have someone else as the trustee managing those funds to use and be like, hey, do you need this? Are you protecting your own funds, not using those and just asking for money from this family trust to just spend it down? If so, we're not going to do that. We're going to make you use the money that you have. Mm-hmm. So there are, these tools have come back into play. I shouldn't say come back, but like most tools, there's a time and a place for it, and so where I think they were perhaps used more frequently 20 years ago, those types of things I don't see as frequent, but these are great circumstances to use them.
Okay. How often would you say that this comes up in our office?
That is a great question. It is not the majority, I will tell you that. I would say that probably it's somewhere around 20 to 30% of the cases that come into our office have these blended family issues. Um, and even then, I would say a lot of those aren't necessarily issues because a lot of them are people who've been married for 20, 30, 40 years. And there is that level of connection between the children and that parent who isn't their parent.
I had a client recently who was calling us on behalf of his ex stepmom, and he was still caring for her.
We do see that.
And I was like, you're a really good person for doing all this. And, they were going through the Medicaid process, just an Alzheimer's diagnosis. So really like rough circumstances and not even blood related, so we do see all types of families come in here. Any other considerations other than, pre-planning with a prenup or postnup?
So, I mean, I think one of the things that people need to consider then, especially as they get to that stage in their life, is, not just for your trust or your will and who's going to make those decisions, who's going to manage the money, but also while you're alive, who is the person that you want to make decisions for you now? Sometimes if it's medical decisions, you might want your children to make that and not this new spouse. You may love each other, but your kids are probably going to have a different view on your care and honoring your wishes as compared to someone who you've been married to for 5 years. Mm-hmm. You've known your children for 30, 40, 50
their
years.
Entire lives.
Their entire lives. That's right. Sometimes you might name them to make decisions together, give them the ability to both make decisions. In powers of attorney, we see that sometimes. Name my spouse, but also name one of my kids so that they know what's going on. And if God forbid something happens to me, they can kind of also just make sure that everything's going the way it's supposed to, that nothing gets squirrely. What we see most frequently is not that it's the new spouse that's creating the problem, it's the children of that spouse who are in their ear saying, hey, those kids didn't do anything for you. Why are you going to leave anything to them? You really should just leave it all to us because we've been here to take care of you and we've been here for you for your entire life. And, and ignore the fact that maybe the money wasn't yours to begin with. It's yours now. And so, leave it to us instead. So, I always tell people, I believe that you trust your spouse and I believe you should trust your spouse. It's not your spouse I'm worried about. It's your spouse's children. It's their potential next marriage. It's other people that will be around that spouse that, after you're gone 3, 5, 10 years, whatever, their devotion to your family or children starts to wane. And that's where things happen.
Mm-hmm. Yeah. A lot to consider.
Yeah.
And that's part of the reason why no estate plan is the same.
Oh, for sure.
We're never going to have just a form for people to fill out and then we, create a trust based on what you fill in.
Yeah, unfortunately, I think a lot of people don't fully appreciate the complexities and issues that can arise in estate planning in general. I think some of us practitioners probably take it for granted because we've been doing it for so long. We just intuitively know the questions to ask and the things to plan for and prepare for, but the average person doesn't know what they don't know, and that's what I would say kind of about with AI is, it's as good as the questions you ask as the prompts that you give it. And that's true of estate planning as well. If you try to do this stuff on your own, if you go to the online stuff or the whatever, you don't know what you're missing. You don't know what pitfalls await for you out there. And so that's what makes it challenging because there's so much to consider. But
Yeah. And part of the reason why a trust is almost always a better option than a will, even if you have minimal assets. The will is just not going to be as specific and nuanced as what a trust will do to protect your assets from probate.
that's right.
All right. Well, thank you, Jeff. And thank you all for watching another episode of the Elder Law Out Loud podcast. We'll see you next time.